My question, therefore, is, when you submitted that document, was it part of your investigation that you submitted to the office of the DPP that before they took that decision, that Khumalo is also complicit in the murder of Senzo Meyiwa?
My Lord, yes. I presented all the evidence as it is. And as I indicated, part of my recommendation or request was that she should be charged. But then there were further instructions insofar as she is concerned at that stage, my Lord.
And based on your investigation, you were satisfied that there was a reasonable suspicion which you formulated based on your investigation to believe that she is or was complicit in the murder of the deceased?
Yes, I was, my Lord.
Now, this is what the state told this court in terms of Section 144, subsection 3A of the Criminal Procedure Act, which is called the Summary of Substantial Facts. This is how it reads.
Once again, what has got the summary of substantial facts to do with the witness? The witness gives evidence, said he presented the docket to the DPP and the DPP exercises discretion. If my learned friend has got the legal argument to make out of summary of substantial facts which are not binding on the state, it's for him to present that argument to the court and not to this witness. We submit that his current line of cross-examination, my Lord, is irrelevant as far as this witness is concerned.
As it is the court, my Lord, I think that it's a misdirection, it's a misrepresentation of fact. It can't be had to be said that an information that relates to the investigation of a case wherein an investigating officer is under oath and is taken up on his investigation, then it is argued that that line of cross-examination is irrelevant. What is it that I am coming up with which does not have to do with this case in my line of cross-examination? I dare my colleague to stand up and say, in terms of what you have said now, has got nothing to do with this case. Then I would say, yeah, no, they are making a mistake. But everything that I've said so far has got everything and anything to do with this case. I've never spoken about anything that has got nothing to do about this case. Unless, of course, the guilty are afraid, I would understand. But up to thus far, there is nothing that I've come up with which has got nothing to do with this case, madam. Definitely.
This witness testifies about the course of the investigation, what the DPP has decided, and what the Director of Public Prosecution has formulated in the indictment, in the summary of substantial facts, has got absolutely nothing to do with this witness. And it was on that basis, my Lord, that we made the submission that this line of cross-examination is relevant to this witness. He was not party to the compilation of the summary of substantial facts and the indictment. We submit that that line of cross-examination should be disallowed.
May I respond?
Yes.
Yes. I think my colleague is running away from telling the court about what you read being a prejudice.
What?
Prejudice to the accused. These accused persons, my lords, have been arraigned to this court to answer the allegations that are contained in the summary of the substantial fact. And there is nowhere in the summary of the substantial fact where Khumalo is mentioned as a kingpin. Instead, in the summary of the substantial fact, Kelly is mentioned as a victim. I am asking if at the very inception, at the drawing, at the preparation of the summary of the substantial facts, the state was aware that Kelly was a kingpin, so that when it decided to draw this summary of substantial fact, that should have been a factor to be taken into account, so that when these accused persons come and answer on the allegations that are against them, they know that amongst others, we are before this court to answer allegations that we were in consort. We worked together with Kelly Khumalo to assassinate Senzo Meyiwa, and that is not there. They are now expected to answer on something that was initially not put to them at the beginning of the trial. Remember, my lord, when the charge is being put against this accused person, the summary of the substantial fact is also read into the record. That is part of the charge sheet. There is nowhere where they were called upon to come and answer that they worked together with Kelly Khumalo. That is the reason why I am basically asking, and I'm not trying to indict any person. I'm getting somewhere with this line of cross-examination as to whether or not at the preparation of this indictment was the state aware that Kelly Khumalo, such a very, without Kelly Khumalo, would not have been here basically. As per the testimony of Brigadier Gininda, we would not have been here because accused persons would not have had anyone to come. According to the allegations of Brigadier Gininda, these accused persons would not have had anyone to entice them to go and kill Senzo Meyiwa. But that is not contained in the summary of substantial fact. It doesn't matter, my lord, whether a person is charged or not charged, but the summary of substantial fact must contain the information that is contained in the case docket, so that when the accused persons are confronted with that allegation, they are able to respond accordingly. And that has not happened in this case, which is the reason why I am compelled to find out, because now they are expected in the middle of the trial to answer to something that has not been there at the inception of the trial. There's nothing wrong in me finding out whether or not at the time at which the decision was made, the state was already aware that Kelly Khumalo was a kingpin.
But you're arguing something different.
No. Okay, my lord. Let me hear. When the court says it's different, in what way, my lord?
No, let's play your question first, because you're into the merits, etc.
No, I'm responding to the state, my lord.
What were you responding about the irrelevance of this witness being cross-examined on the content of the indictment?
Yes.
Which, according to you, you're saying it's not relevant for this witness because it is the Director of Public Prosecutions who drafts the indictment, including even that panoply of facts.
Yes.
And that you also say that, but even that also doesn't bind the state.
Yes.
I thought that was what we were talking about.
Yes.
Now we're talking about Kelly Khumalo.
No, my lord. The Director of Public Prosecution, yes, does draft an indictment, but he's drafting an indictment based on what facts?
No, fine. You
Who brings the facts to them?
Mr. Mnisi, you can argue those facts. But if you read that act,
yes,
the
section,
it says in the opinion of the Director of Public Prosecution, not this witness.
That is correct, my lord. But now, if it is in the opinion of the Director of Public Prosecution and the witness includes something which in the opinion of the Director of Public Prosecution has not been included here, must we then fold our arms and say no? Because the Director of Public Prosecution has decided not to include this, we should also not take this witness on that evidence.
Then you should have requested further particulars.
My lord, we did not.
No, that's the procedure.
Yes.
Am I correct, sir?
Yes.
Otherwise we'll be here the whole day. When you are hit with, your client is served with an indictment.
Yes.
You've got a right to request further particulars and further and better particulars. Did you do that, sir?
Let me respond, my lord.
Yeah.
Yes.
Yeah, fine.
There is no way where in the indictment it is mentioned that Kelly Khumalo is a kingpin. Had that been mentioned from the onset, we'll definitely have requested further particulars. There is nowhere in the indictment where it is mentioned that Kelly Khumalo is a suspect. Instead, in the indictment, it is specifically mentioned that Kelly Khumalo is a witness. How could we then have been enabled to request further particulars when we did not know that Kelly Khumalo, in the mind of the investigating officer, Kelly Khumalo is a kingpin?
Kelly Khumalo, sorry.
Yes.
Kelly Khumalo Kelly Khumalo is not charged in this court. I don't see her.
Yes, she is not charged, my
Yeah,
lord. But
so
the fact
why should I respond to that? I only respond to persons who are charged.
that is
Where
correct.
there's litis contestantio
Yes,
between the accused and the state.
Yes,
Kelly Khumalo, I don't know.
Yes, my lord. Her not having been charged, my lord,
Yeah, you can argue that.
is not a, is not
Okay,
a, is not a.
ask that very question to this witness. Every question you want to ask him, ask him.